Hi. So basically, I'm going to talk about juries. So basically, let's start with the history of the jury system. Juries have basically been used for over 1,000 years. Originally, they were used for providing local knowledge and information, and acted more as witnesses than decision makers. By the middle of the 15th century, juries had become independent assessors and assumed their modern role as deciders of fact, such as why we have them today. Right. Modern day use of juries. Let's think about Crown Court would be type of case would probably be serious criminal cases, murder, manslaughter, rape, blah blah blah. The role, decide the verdict, number of jury 12. High Court, defamation, false imprisonment, malicious prosecution, any case of alleging fraud. Decide liability, if fined for the claimant, also decide amount of damages. So that's basically like civil cases. County Court, again, the same as civil cases, but instead of 12 jurors in County Court, they have 8. Yeah, so that's their role in the various courts. Juries in criminal cases. Well, obviously they'll be in criminal cases when you join the Crown Court. Surprisingly enough, they only account 1% of all criminal cases. This is because 97% of the criminal cases are dealt within magistrates' court. The ones that do go to Crown Court, 2/3 of them plead guilty. Not guilty. Like, they plead guilty, okay? So why are they important? Well, basically, as said before, 1,000 years ago, over 1,000 years ago, juries were basically witnesses of the public that turned into deciders of the public. And they represent from rich to poor, from culture to culture. So, Sir Alan Sugar could be sitting next to an everyday Joe who lives in a council house. And they represent a wide variety of society. And next to them could be an Indian, a Pakistani, an Arab, an English guy, an Irish guy, a Scottish guy, an Asian. And again, those are representing the different cultures, different religions, different views of life, different walks of life. So that's why they're important, because 12 minds are better than one. So what if the judge is a racist? Or doesn't like, or is against a certain type of religion? Well, 12 minds predict whether they're guilty or not. So, obviously it's better. Now, in civil cases, are only used in very little circumstances, and but where they are used, they have a dual role sort of. They decide whether the claimant, so the person putting forward the case, has a case or not. Then, if they decide that the claimant has won the case, the jury also go on to decide the amount of damages the defendant should pay to the claimant. A jury can be refused by a judge if the judge feels that the case involves more complicated documents or accounts or scientific evidence and blah blah blah. That is not suitable for a jury trial, because juries are not actually legally trained, or not trained in the field of any legal advice, because they're not allowed to be if they are on the jury. So, therefore, if they bring in complicated evidence, which is not very understood by an everyday Joe, then what's the point of having a jury? They might decide wrong or not understand, and they would never be able to explain how they came up to a verdict because they're sworn to secrecy, which we will get to a bit later on. But in 1933, the Administration of Justice Act limited the right to use of juries so that juries could not be sued for disputes over the breach of contract. So if someone breaches a contract and doesn't do what they're told, juries cannot be brought in because juries are not part of their contract and blah blah blah. But the present rules for when juries may be used in civil cases in Section 69 of the Supreme Court Act 1981 for High Court cases and Section 66 of the County Court Act of 1984. Moving on. The qualification of juries. Basically, age between 18 and 70, registered vote as a parliamentary or local government elector, resident in the UK, Channel Islands, or the Isle of Man for at least 5 years since their 13th birthday. They must not be a mentally disabled person, so it must not be a little bit cuckoo, or have a past criminal record. Like manslaughter, murdering, raping. Yeah, you have that on your thing, you won't be able to be a juror, just saying. Right. What disqualifies a person from, permanently from jury service is imprisonment for life, detention for life, or custody for life. Detention during Her Majesty's pleasure or during the pleasure of the Secretary of State. To imprisonment for public protection or detention for public protection, an extended service, a term of imprisonment of 5 years or more, or a term of detention of 5 years or more. Those in the following categories are disqualified for 10 years. At any time in the 10 years served a sentence of imprisonment, or had a suspended service passed on them, or community order or other community sentences passed on them during these 10 years. Anyone who is currently on bail in the criminal proceeding is disqualified from sitting as a juror. If a disqualified person fails to disclose the fact that and turns up for jury service, they may be fined up to £5,000. That will make your wallet bleed. Also disqualified are deaf people due to the fact that the translator would not be needed and a 13th person is not allowed in the juror's room while they make a decision, as this is a contempt of court. Sucks, but deaf people are not allowed. Right. Selecting a jury. How are these jury people selected? Simply, a simple way of putting it, at each Crown Court there is an official who is responsible for summoning these people, right? And, summoning enough jurors to try the cases that will be heard on every 2-week period. So names will be selected at random from the electoral registers done through a computer selection. By the central office. Summons more than 12 jurors, as at most courts have more than one courtroom, which would make sense, Right. Now, are jurors good or bad? Right. An advantage would one of them would be secrecy. The jury discussion is done in private and there cannot be any inquiry for how they came up with the verdict. Section 8 of the Contempt of Court Act 1981, any discussion of what happened in the jury room is considered contempt of court, which is a criminal offense. So why was it brought in? What's the point? Well, basically, because newspapers were paying jurors large sums of money for what was happening and how they'd interpreted the evidence. So is that good? Well, is it good to be secret? Well, yes, because the jurors would not have any pressure from the public, no outside influence when they were deciding, and because jurors are not legally trained and therefore do not have to follow the ruling of past similar cases or follow acts of parliament, nor do they have to give reasons. They can just pass a verdict on what they feel is morally right. Yeah. What else can I say? Now I could probably say a lot more, but hey. Another advantage of having a jury that I can possibly think of is a jury is seen as the public, as one of the fundamentals of a democratic society. Also, people are comfortable with tradition, and as a jury is a very old tradition. I mean, think about it. I mean, past 1,000 years ago. People have more confidence in the fairness and the tradition of juries. And like I said, jurors are not legally trained, so they say what they feel is morally right. I'm just waffling on about it, isn't it? It's also viewed, juries are seen as the open system of justice, because the jury is on a random selection basis. None of the jurors should know the defendant or should be connected to the case in any way. Also, due to the random selection, the jurors should be from across the society, cancelling out any bias or prejudice. Alright, I don't know why I'm backtracking, but yeah, take it with the backtracking. Secrecy. Because obviously I've just lost my point, but I'm just rambling on, but you know what, it's important, so just listen. When the jury is left in secret, it gives them the ability to keep away from the public pressure and allows them to make their decision on what they feel is right and not directly based on the law. I don't know why I said that, because it's just important, so just take it, yeah? Juries are also impartial. Well, impartiality. Because the jury... Sorry, I lost my shirt. Because the jury is on a random selection basis, like I've said, they shouldn't know the defendant or anyone in the courtroom, therefore they have to be impartial. Now, the disabilities of having a jury is first decisions. Yeah, let's go with that one, yeah? First decisions, because it's a fancy word. Though the jury do not have to
follow and justify law, but some view this choice as unjustified. Juries have refused to convict in obvious cases. Let's take happened with the versus Roland Popple in 1991. Basically, it's the jury just messed up on that one. Another case on which the jury acquitted the defendant, or the evidence was clear, was R versus Cronald in 1996. Secrecy then played a part in this, because reasoned decisions are known, therefore given if the jury really understood the evidence in the case as well, thus questioning the justice of their decision. Because juries are not legally trained, they wouldn't exactly know or understand the evidence given. Right? Like, if someone rocket science in front of me, I wouldn't know about it, therefore I would not be able to justify the answer to the question given. Such as was the case of the Jason R. versus Mirza. He was a man who settled in England in 1908 who needed an suspicions grew against Mirza as the jury felt that the answer was a mirage, when in fact genuinely just not understand England, which is surprising because 1988, but you could obviously see, that there is problem times. Bias. Sometimes the juries can be, fortunately, the risk of some of the juries being biased against even prejudice or racist, affecting the verdict and thought process. Which case, think of what else I could possibly. With jury cases, do that. Down with juries in civil cases, the liability of the parties in the case, and also the amount of damage awarded. It was very greatly, as each jury has its ideas and does pass case. The amount therefore is totally unpredictable, which makes for difficult for law to advise. unreasoned decisions. The jury does not reason for its decision or the amount it's towards. Bias, might be racist or prejudice, whatever. Cost civil cases are expensive and these add to the and the case is likely to last long. Let's think of alternatives. There's a trial by judge, a panel, a judge by liaisons, and a mini jury. But then again, juries across the world do not all the same. Take Italy, for example, and the case. The reason why I chose because basically the jury were left and how they come up with the verdict, what they said happened, what evidence they tried to abandon and lost deceit and basically was found the alien jurors came out and gave out was necessary and how they come up with it and they got that completely is a jury and the secrecy